I'm here to talk to you about veterans preference and also other property rights if we have a chance to get that far. I'm always amazed when I pick up the Iowa Code, what little gems I find. And I can tell you, I practiced for 20 years before I ran across veterans preference. And I still deal with a number of lawyers who work in areas in which I work. And very few people really know anything about veterans preference. Veterans preference has been around since 1904. And it was buried in the code, and it became less important as other statutory rights developed into the mid-20th century. But with the destruction of public employee rights by the 2017 legislature, there are many more reasons for folks to bring veterans preference charges against municipalities. And that's what I want to visit with you about today. If you are a veteran, you are entitled to a number of rights under Iowa law. Well, the first thing you have to ask yourself is, well, who's a veteran? A veteran is an honorably discharged person from the armed services who served in a number of different wars or conflicts. And the current ones that you'll see or run across are Vietnam, Lebanon, Grenada, Panama, and the Persian Gulf. So in effect, anybody who's been in the military since August 2nd, 1990, in the never-ending wars in Afghanistan and in Iraq are covered as a veteran. But there are other folks, things that you might not have run across. So for instance, I think there are a couple of very minor conflicts. So for instance, if we had anybody who was still alive during the Chinese river incursions by the United States in the 1930s, they're covered. There's all sorts of little oddities that are there. But the other group, besides those that were in the active duty armed services, are folks who were members of the reserves. So again, if you were honorably discharged and you were a member of the reserves for 20 years, you are covered as a veteran. And then the other one that is difficult from a record-keeping standpoint is if you were a reserve soldier and you were called for 90 days of active service, then you are covered. Now you have to, however, exclude training from the 90 days of active service. You have to look at a form that's called, they get from the Department of Defense, and every veteran has one. They're called the DD-214. You need to find a friend who can interpret DD-214 documents for you. Because if you have to figure out whether there's 90 days of active duty that excludes training to an uninformed eye such as myself, you will never figure it out. So where's a good place to develop a friend who can interpret a DD-214 for you is every county in Iowa has a Veterans Affairs office. And that Veterans Affairs office is staffed by an executive director. That executive director interprets DD-214 documents every day. Make that person your best friend if you are worried about or having to deal with veteran preference forms. Next thing that you should think about is how do you identify somebody who is a veteran? And again, there are things that are wonderfully tucked away in the Iowa Code. Iowa Code provides that a veteran is entitled to preference in appointment over anybody else who has no greater qualifications. So if you have two people in equipoise regarding their qualifications, it is the veteran who is supposed to get the appointment. How do you know the person's a veteran? Well, every single job, not only for the state of Iowa, but for all of its political subdivisions, and by the way, that's going to include not just cities and counties, but all 28E entities, library boards, you fill in the blank. You are required under state law to have an application. And the application under Iowa law requires that you ask about military service during wars or conflicts. So you have to use an application for public employment, and it has to ask, are you a veteran? Have you served during a particular time period, during a conflict, during particular wars? Let's see. The next thing that you should probably know is that once you are a veteran, if there is a competitive exam or there's a competitive civil service type exam in order to obtain that job, you have to give 10 days notice by posting that job. So it's not just civil service, it's actually any job. So all jobs in the state of Iowa, by the state or by political subdivisions, are supposed to be posted for at least 10 days. And you do that just like you would post an agenda under the open meetings law. The other thing you should keep in mind is if you do have competitive exams, so think civil service, if you are a veteran, you are entitled to 5 extra percentage points. Not 5 points, 5 percentage points. So for instance, if you have 100 possible points, you score 80. If you are a veteran, you get an additional 4 points because that's, as a history major who's not very good at math, even I can come up with the 5% there, which is you do 4 extra points. If you are a person who has a service-related disability, you get another additional 5 percentage points. That takes us over to, well, what are some of the advantages if you are a veteran and you are entitled to veterans preference? The best advantage to all of those folks is that there are only 2 reasons why a veteran can be removed from appointment. They are incompetency or misconduct. And you can only be removed after you've been granted a hearing and you have been given notice of the charges. Only then, after that hearing, can you be removed from employment. The right to challenge the decision made at that hearing is by certiorari, which we'll talk about later. And the other issue that we'll have to talk about later is what about the impartiality of the hearing body, that is, the person or entity that is making the determination on the veteran's preference, do they have to be impartial? So what's incompetence? Which is one of the ways that you can be removed. Incompetence, I'd like to tell you, has been actually defined by the Supreme Court, but I'd be lying, it hasn't been. What you can look to are the cases as to what's an example of misconduct. And my favorite one is this Collins case. Collins is, when I first started practicing, there were still state liquor stores. They have gone the way of the Edsel. They are no longer around. But everybody who used to work in a state liquor store was a state employee. So one of the people that worked in a state liquor store was Mr. Collins. Mr. Collins had a disability, so he could not do most of the tasks of a state liquor store employee. So he couldn't stock the shelves, he couldn't unload the trucks. So what they had him do was he was the sales clerk. But he wasn't really good at being a sales clerk. So one day, his bosses decided, well, let's take a look at how many mistakes we've got. And they figured it out, and they found out that during 1 month, of a total of 28 errors on state liquor store receipts, he'd made 20 of those 28. The next month, it was 10 out of 15. The next month, it was 20 out of 23. Then they looked at a broader category, and they found that looking at the 13 employees that worked in that store, he'd made 96 out of the 191 errors. The next month, when there were only 11 employees, they found that he'd made 37 out of the 66 mistakes. Based on that, the state found that he was incompetent because he did not have the actual skill or the degree of accuracy displayed by the average or the other employees at such work. And as such, he was incompetent. So when you're thinking about incompetency, you are going to have to prove that this employee can't do their job. So look for evidence of mistakes to see if you can show that. The next and the only other basis by which you can be removed from employment for veterans preference is for misconduct. And again, there really aren't any wonderful definitions of misconduct like there are in unemployment law. So you have to look at one of the examples. And again, my favorite is Edwards versus Civil Service Commission. Edwards was a police officer in the 1930s in Sioux City. In Sioux City, back in the 1930s, there was a horse racing track. And one afternoon, Mr. Edwards is off duty. He's at the track, and a buddy of his is losing big time. He's betting on all the wrong horses. And by this time, they've all had something to drink. In fact, they've had a little bit too much to drink. And one of the other patrons, who's sitting in a box or a chair next to the police officers, starts making fun of the police officer who keeps losing on every bet he makes. And eventually, that officer gets a little perturbed. And at that point, Mr. Edwards, who again has had too much to drink, steps in. And he shows his badge to the patron who has made fun of his brother officer. And the patron says, "I don't think you're policeman enough to kick me out of here." That's always a mistake to say. So Mr. Edwards says in response, "Well, in that case, I'll have to just show you." And he did. And he slaps him, hits him, walks him or drags him out of the track. And unfortunately, the next day, the police chief found out about it and promptly fired him. Went up to the Civil Service Commission, where the Civil Service Commission finds, yes, he should be fired. But then it went to the district court. And the district court, in the best understatement that I think I've ever run across in an Iowa reported case, wrote, "Well, the plaintiff was indiscreet in the arrest, and he was further indiscreet in assaulting the other patron, and promptly restores him to employment." Sioux City appeals it to the Supreme Court, and the Supreme Court says, no, he was not indiscreet. He was assaultive, he was violent, he was drunk, he was engaging in conduct that was unbecoming to an officer. And as such, we find that that is guilty of misconduct, and as such, he is not entitled to veterans preference because he was removed for actual misconduct. So if you can only be removed for misconduct and for incompetency, what happens if you're wrongfully removed? Well, there are no monetary relief that's awarded to a veteran who successfully gets him or herself reinstated to employment. And there's certainly no attorney's fees that are allowed. So how is it that you can make this a monetary issue? And the way that it can become a damage claim is this a violation of Section 1983? And back in the early 1990s, the Eighth Circuit held in a case called Winter versus Saragorder Conservation Board, that a veteran who was also a park ranger, who was removed without a hearing, was entitled to bring a Section 1983 claim because it was a violation of due process. And he was awarded back then $40,000 plus attorney's fees. So there is a real argument that anytime you fail to give a hearing before termination in veterans' preference, you have violated a constitutional due process right, and you are subject to Section 1983. But there's a case I want to talk to you about that's not in the outline that you can argue shows that Winter was wrongly decided. About a dozen years after Winter was decided, there's a United States Supreme Court case that's called City of Rancho Palos Verdes versus Abrahams. And it's found at 544 US 113, and it's from 2005. So 544 US 113, 2005, City of Rancho Palos Verdes. What the issue in Palo Verdes was, is there a Section 1983 claim when there is a statute that otherwise provides a remedy? And the statute at issue was the Federal Telecommunications Act, which provides a remedy if you violate it. At the Supreme Court, there's no opinion that gets 5 votes, but the lead opinion is by Justice Breyer, which garners 4 votes, and then Justice Stevens concurred. And what the plurality held was that a provision of express private means of redress in a statute is ordinarily an indication that Congress did not intend to leave open a more expansive remedy under Section 1983. And then the case further holds that an express provision of one method of enforcing substantive rules suggests that Congress intended to preclude others. So the issue is there a Section 1983 violation when you fail to give a veterans preference hearing? Winter in 1991 says there is. A related case under federal law in Rancho Palos Verdes, a dozen years later, says there isn't. Also call to your attention one other very important point in Winter. Winter has a great little footnote. In the Winter footnote, it says that if you suspend an employee pending the veterans preference hearing, that you have to suspend the employee with pay. So you don't suspend without pay, you suspend with pay. Now what the Winter footnote refers to is a line in the US Supreme Court decision in Cleveland Board of Education versus Loudermill, which we'll talk about a little bit later. If you go back and read the actual language in Loudermill, it's not as clear and direct as the 8th Circuit said it was in 1991, but those are at least things that if you get sued for a 1983 violation, you should be looking into those issues to see if you can avoid liability. So if that's the law regarding Section 1983, are there times when you don't have to give a veterans preference hearing? And there were, at least until last summer, or excuse me, last 2017, which is the Iowa Supreme Court on a couple of occasions has held that if you have rights under civil service, you don't have to be given a veterans preference hearing. And the citation for that is Andriano from 1961. And what the Supreme Court there, and in a subsequent case called Kern versus Saydale School District, says that if you are a civil service employee, the exclusive way to challenge your adverse employment action is through the Civil Service Commission. Civil service was passed in 1907, so it is a later statute than veterans' preference in 1904. The other thing that the Supreme Court has always said is that veterans' preference is a general statute as opposed to a specific statute. In contrast, the Supreme Court always says civil service is a specific statute. So under the classic rules of statutory construction, specific always controls over general, and if they're irreconcilable, newer always trumps older legislation. But the issue you got to ask yourself is when the legislature changed civil service law last year, when for everybody other than certain public service or public safety workers, civil service no longer protects somebody from a misconduct firing. Misconduct was taken out of civil service as a basis for termination. Question you need to ask yourself is, are civil service and veterans' preference still irreconcilable like they were at the time of Andriano? And there's an argument to be made that those statutes aren't irreconcilable, because if under veterans' preference, you can only be removed for misconduct. And civil service no longer provides for misconduct terminations. It may be that you can argue that the statutes are no longer irreconcilable, and you may have a right to a hearing both under veterans' preference and civil service. Again, none of that's been litigated because all of this happened with the 2017 legislative session. Similar thing happens with collective bargaining. Prior to 2017, the Supreme Court had always held that the more specific right under collective bargaining governs as opposed to a civil service hearing, or excuse me, as opposed to a veterans' preference hearing. And that's the cases cited there, both Kern and Devine. But again, now you have to ask yourself, is collective bargaining still irreconcilable with veterans' preference? Because again, other than public safety workers, there's no provision in Chapter 20 regarding tenure or a mandatory bargaining over reasons for termination. Because mandatory bargaining is now limited to base salary. So again, if you are a veteran and you have collective bargaining rights, you may want to be thinking, am I entitled to both? Are the Kern and Devine cases still good law? But veterans' preference isn't a complete panacea of protection for workers. You can be removed through abolishment. What's abolishment? Abolishment is when a municipality in good faith decides it no longer needs a particular job. So just because you are a veteran and you have a job, you don't have a permanent sinecure. You have a job that the municipality could decide we no longer want to keep. Wood versus Lovelace is an example of that. That takes place back in the late 40s and early 50s in the city of Ottumwa. And the city of Ottumwa decided they were going to get rid of a position in the police department called, quote, inspector. So the one person who was abolished was Mr. Wood. And Mr. Wood brings a claim saying, you could not abolish my position. Supreme Court says, yes, it can be abolished. And Wood says, hey, I was bumped back into a position as a patrol officer. And by the way, nothing's really been abolished because there are still 50 police officers. So there were 50 police officers before the abolition, and there are 50 after the abolition. The only difference is there's no longer a job that's called inspector. Supreme Court says it doesn't really matter that you don't have a diminution in the number of employees. As long as the position itself was eliminated in good faith, then the city can, or the municipality can go ahead and abolish the job. So what are other exceptions to veterans' preference? Well, there is a statute that provides that there are some people that don't get protection under veterans' preference. They are what you might expect: a private secretary, the deputy of an official or department, or any person holding a strictly confidential relationship to the appointing person. And you might be tempted to think that, oh, that language is very similar to the language in collective bargaining statute, chapter 20. In chapter 20, there's a definition of a confidential employee. And there, under 20.3, a confidential employee is somebody who either works in the personnel office, has access to information used in negotiating, or has a relationship with the officers who are negotiating on behalf of the employee or the employer. So you might think that they're the same thing. You would be wrong. You should take a look at a case that we previously cited. It's called the Andriano versus the City of Des Moines. Andriano was an assistant police chief. Clearly, he is probably either a deputy of a department or he's got a confidential relationship with someone. That's an easy decision. The court says he is not protected by veterans' preference. But then they list all the people that they have previously held were not entitled to veterans' preference. It's a very broad group. It includes an assistant city attorney, that's a no-brainer, a junior or assistant examiner in the auditor's office, the state superintendent of printing, but the one that's really important is they've held that a jailer in a sheriff's office is a position of, or as a person holding a confidential relationship. And then an inspector in a DOT, and even a bookkeeper in the state treasurer's department. So confidential relationship under veterans' preference is a very broad group. And in fact, the Supreme Court, I believe in Andriano, says, quote, "A confidential relationship is broad. It applies generally to all persons who are associated in any relationship of trust and confidence, where the duties are not merely clerical and require skill, judgment, trust, or confidence. Courts are inclined to regard appointees as holding confidential relationships to the appointing official." So one of the things you always need to ask yourself, even if you would not intuit that the veteran has a high-level job, under those old cases beginning with Andriano, that person may actually be in a confidential relationship. And that will limit substantially who's protected by veterans' preference. Next question that arises is, can a veteran waive his rights or her rights under veterans' preference? There is, and I would have told you up until Christmas of 2015, that the answer is no, that those rights are guaranteed by statute, and as such, they're statutory rights that the legislature has imposed on employers and belong to employees, and they can't be waived. However, there is a unpublished Court of Appeals decision called Walk versus St. Angar Community School District that says veterans' preference rights can be waived. What happened in Walk is a school bus driver. He's also a veteran, so he's entitled to veterans' preference. However, he signed a contract when he began work. And in the contract, he says he is an employee at will. Now, of course, you always have to give some thought as to, isn't it an oxymoron that you have a contract saying you are an at-will employee? But be that as it may, Walk gets terminated. And he then claims, I was entitled to veterans preference. Court of Appeals says that that's not true, that that right can be waived. Now, keep in mind, Walk is unpublished. The other thing to keep in mind is what the Court of Appeals cites to are not veterans preference cases that say veterans preference rights can be waived. It cites to that rights under the drainage laws can be waived, and that rights under a written lease in a commercial property can be waived, and draws the conclusion therefrom that veterans preference rights can be waived. The other questions I'd ask you to think about is, how can you waive a future claim? Because that's what's happened in Walk, is he is found to have waived a future claim when he signs the contract. And then ask yourself, how is it that you can waive certain civil rights? So for instance, sure, you can waive an ADEA claim because Congress set out how you do that. How is it that you waive a future civil right under Title VII or under the ICRA? All of those are things you ought to be thinking about as to whether Walk is actually good law. So that takes us over to the next question, is how do you do these hearings that are required by the veterans preference law? In Kern versus Seidel, which is one of the cases previously cited in the material, the Supreme Court says, quote, "The type of hearing called for by the legislation is not described in the statute." That is an understatement. There is nothing in the statute that describes the hearing. And part of that is, remember, this dates from 1904, long before the 1960s civil rights era, where certain constitutional requirements of due process are imposed on the states under the federal constitution. So what do? First of all, who holds the hearing? The statute doesn't really say who holds the hearing. You have to look at other sections of Veterans Preference Act, and you'll find things like the appointing authority or the appointing officer is the person who is supposed to investigate qualifications, or is somebody in a confidential relationship to the appointing authority. So I think the answer is, who holds the position or holds the hearing is the appointing authority. Then you have to ask yourself, who's the appointing authority? Well, in some places it may be easy because there may be an ordinance or a statute that says who appoints an employee. In a county office, it may be a particular elected official. It may be the board of supervisors. In a city, it may be the city council. In a library, it's probably the library board. But what about all the wonderful little cities in Iowa where there is nothing in the ordinances that say who appoints someone? And I can tell you, I've had those happen regularly when you have to figure out who has appointing authority, and there's nothing in the tiny towns ordinances that cover that. So then you're going to have to put on your creative hat to try to figure out who to do that in front of. Well, also, what happens when the appointing authority, by the way, is the person or the board that is bringing the claim to fire someone? Doesn't that suggest that they have prejudged the decision that this person needs to go? That became really troublesome this summer, because there is another Court of Appeals decision called Burke versus City of Lansing. And I think this one is published. And in Burke, it's not a veterans preference case, but in Burke, there is an open records violation that has happened. And the county attorney has now brought a claim against all of the city council members. And the city and the county attorney says, tell you what, I will settle this case if you agree to vote out of office council member Burke. So all of the other remaining council members, who, by the way, are defendants in the county attorney's open records violation and open meetings violation, vote to toss Mr. Burke. In addition, in that hearing, the city council people who were voting to take Mr. Burke off the council are also the folks that are in effect acting as the prosecutors. They're saying he should be removed for various and sundry reasons. That case gets up to the Court of Appeals, and the Court of Appeals says there are two due process violations in what you have done. The first one is that you have acted both as the prosecutor and the judge, and as such, under due process, you can't do both. You can do one or the other, but you don't get to be both judge and prosecutor. Second violation they find is that there was a pecuniary interest violation that all of the city council members who voted to terminate the one council member had, because the lawsuit against them, and remember, open records violation and open meetings violations are personal liability for the official. The county attorney said, I'll drop the case if you vote Burke off. Court held that was another due process violation. So now take that to veterans' preference. What happens when your appointing authority has already decided that they want to fire the veteran? Do you have a due process violation, or do you have to come up with some workaround? One workaround is that there is someone, independent counsel, who is appointed as the prosecutor to bring the claim to terminate under veterans' preference. And then the other issue is maybe it's really not a due process violation. Maybe a veterans' preference hearing is really only a name-clearing hearing. And in a name-clearing hearing, it doesn't matter whether the appointing authority has prejudged or not. This is just the opportunity for the veteran to, in effect, clear his or her name. That may be another workaround. But again, there's no case law on that. So that then takes us over to the removal hearings. In the removal hearings, remember, you have to have notice of charges that are given to the veteran. Those charges have to be written. And what I do is I always just prepare a pleading, if you will, like a petition that charges what the claims are against a veteran. Then there has to be a hearing before there's a removal. And remember that winter footnote, the winter footnote says you're supposed to suspend the employee with pay pending the hearing. The burden of proof is, that's wrong on the fourth bullet point on my PowerPoint. The burden of proof is on the employer, not the employee. And then finally, once the appointing authority has made a decision, if that's going to be challenged, it has to be done by certiorari. That then takes us to one of those other wonderful little pieces of the Iowa Code, or in this case, civil procedure, that are buried away, which is what in the heck is certiorari review? Certiorari review is allowed by statute or where an inferior board is exercising a judicial function and they have exceeded their jurisdiction or otherwise acted illegally. It's controlled by the section that's 1400 in the Rules of Civil Procedure. It is a trap for the unwary is a great way to describe certiorari. A certiorari petition has to be filed within 30 days of the adverse action. The judge then must issue a writ. The writ is issued by the clerk of court. The writ commands the defendant to certify to the court at a particular time and place a transcript of the defendant's records and proceedings together with the facts of the case described with, quote, reasonable certainty. The sheriff serves the writ unless it's been accepted by the defendants. And then the return of the writ has to be made by the presiding officer, clerk, or secretary of the board of the tribunal. There are so many traps here. The first trap is if you file a petition for writ of certiorari and you wait and you wait and you wait and the writ doesn't come, the reason is because you as the attorney, as the moving party, have to get the court to issue the writ. I've talked to judges who, when I've visited with them about certiorari, have been on the bench for 10 years who will say, you know, I know that certiorari exists, I just don't know anything about it. It is the judge's job to issue the writ and directs the clerk to issue the writ. But if the judge doesn't know that he or she has to issue the writ, then the writ doesn't get issued. So the writ has, it's the plaintiff's counsel who's got to take the lead in getting the court to issue the actual writ. Once the writ is issued, then the defendant sends up the entire record that existed. Most of the time, you are hopefully going to have a transcript. So when I do a veterans preference hearing, I always have a court reporter there. If you don't have a court reporter there, then the question becomes, how is it you're going to produce a, quote, transcript of the defendant's records or proceedings? Or do you simply have to do the facts of the case with reasonable certainty? And then who's going to agree as to what the facts of the case are with reasonable certainty? So make sure that if you are doing a veterans preference hearing, you shell out for a court reporter. You will be benefited in the long run. The other trap for the unwary with certiorari review is a case that's not in the outline, but it's called Bontrager, B-O-N-T-R-A-G-E-R versus Iowa City Board of Adjustment. And it's found at 748 Northwest 2nd, 483. Bontrager, 478 Northwest 2nd, 483. Bontrager, in the context of certiorari from a land use decision under Chapter 414 of the Iowa Code, describes when it is you can bring in extra evidence at the trial of certiorari. And in effect, it says that if you are only challenging the sufficiency of the evidence as the basis of illegality, you don't get to bring in new evidence, so that you are going to be stuck with the record you created at the veterans preference hearing in almost all cases. So that gets us through veterans preference and takes us to other property rights where you may have to hold a hearing. When do other property rights exist? Other property rights exist for a hearing, sometimes in a contract. So if a contract requires for cause termination, that's likely a property right. State law is normally what defines property rights. It's not federal law, it's state law. And you also have a property right in your good name. So if you are fired because you are accused of being a thief or a racist or something along those lines, you are entitled, in all likelihood, to a pre-termination hearing. You do not have a property right in at-will employment. Under Iowa law, there are some times where the Supreme Court has told us that you do not have a property right, even though you might think so otherwise. But when it comes to Supreme Court jurisprudence, there are two cases that are important. Roth from 1972 was an untenured professor at the University of Wisconsin, and his contract was not renewed. He says that it wasn't reviewed because of a First Amendment issue, but the contract is only for 1 year appointment, and the university stonewalled him. It said, he keeps asking, well, why aren't you renewing? And they say nothing. In that case, the Supreme Court said there is a pre-termination, or excuse me, there's a right to a pre-termination hearing if there was a property right or a liberty interest. But you don't have either, because a non-tenured professor under Wisconsin law doesn't have a property right, and because the university stonewalled him on why it is they fired him, they never caused him a liberty interest or a reputational interest injury. A couple years later, in Cleveland Cleveland Board of Education versus Loudermill, it is a security guard who gets fired. And there the Supreme Court said, under Ohio law, a security guard who works for a Board of Education has a property right because he is entitled to a post-termination hearing under Ohio law. So the folks in Ohio say, hey, we were giving you a post-termination hearing. He claims that he's entitled to a pre-termination hearing. And what the Supreme Court says is, even though property rights are determined under state law, the due process provisions of the United States Constitution require the procedure under which a due process right is determined. Even though state law may require something, we could care less, because federal law requires notice and a hearing, and the hearing needs to be pre-deprivation. That then establishes how you hold it, or that establishes who has a right to a hearing before they're terminated under Iowa law, which is if you've got a property right or you've got a liberty right, you are entitled to a hearing. Now, the Supreme Court, the Iowa Supreme Court has held that there are some times when you don't have a property right. In Sieg versus Civil Service Commission, the Supreme Court said that a police officer does not have a property right to continued employment. A dozen years later, in Burmeister, you have the Court of Appeals deciding whether a deputy sheriff has a property right. What is difficult to figure out is under Iowa civil service law for deputies, deputy sheriffs can only be removed for cause. Cause should establish a property right. But our friends at the Iowa Court of Appeals said, no, there's really is no substantive difference between a police officer and a deputy sheriff, so that based on Sieg, we are going to hold that there is no property right for a deputy sheriff who by statute is only supposed to be removed for misconduct, isn't entitled to a pre-termination hearing. However, again, I think you need to at least reconsider whether all of this is still good law after the changes in the 2017 civil service and collective bargaining rights by the Iowa legislature. So then our friends at the Iowa Supreme Court, let's see, finally provided to us a nice little listing of who is entitled to a hearing for a liberty interest. And that's in Jones versus University of Iowa. That's a few years ago. Was a vice president at the University of Iowa who was fired after there was an investigation regarding sexual assaults by athletes. And what the Supreme Court said is you look to determine that liberty interest by, has there been stigma imposed on the employee that he's been accused of dishonesty, immorality, criminality, racism, and the like. And if you have been, then you are entitled to some type of pre-termination hearing. And the hearing has to at least give the employee an opportunity to respond. The hearing doesn't have to be elaborate. And it can even be a, quote, informal meeting with supervisors may constitute a sufficient pre-termination hearing when it comes to a liberty interest. So folks, that's what I had on veterans preference and on other pre-termination hearings. And if there are any questions, I'm happy to answer them.